Yeah, 'cause this employer has a preschool and a school, and recently they merged the two. They can no longer afford to pay the former preschool principal the same salary she was on. What could I do?
Okay. There's a situation, it's probably the merger probably related to what we call a transfer of a business. So the employees of the old school would have gone over to the new school on the same terms of conditions of employment. So what the law stipulates is if you transfer an employee in terms of what's called Section 197 of the Act, Labor Relations Act, then you can't dismiss an employee as a result of the transfer. However, there seems to be an operational requirement. So after the merger has happened, the transfer has happened, everybody's been carried over. Now they realize they can't afford this person anymore. So there's a simple financial operational issue. The retrenchment procedure, consult with the employee, see if they are willing to accept a reduced salary. Otherwise, will be entitled to retrench the employee.
If a reasonable alternative is an option for the employee and she refuses, what then?
Yeah. So first of all, we don't know what the reasonable alternative will be. So what we'll have to determine, or an arbitrator will have to determine, is whether the proposed alternative was in fact reasonable. But for sake of argument, let's say it was a reasonable alternative. Then Section 41 of the BCA stipulates that if an employee refuses a reasonable alternative for retrenchment, then such an employee is no longer entitled to severance pay.